Here are 5 things to know about pooled trusts in Florida. Number 1, if you're on a long-term care Medicaid plan, anything in a pooled trust does not count against your $2,000 asset limit. This is really important for folks who are on the waiver program or the Medicaid ICP program, whether they're receiving care at home or in a facility. You are typically only allowed to have $2,000 to your name. You could have more than that, any amount more than that, if it's in a pooled special needs trust. Number 2, money placed into a pooled special needs trust is not a gift. That's very important because these long-term care Medicaid plans prohibit gifting. If you take money out of your name within 5 years of applying and transfer it to a friend or a family member, that's considered a gift and there will be a resulting penalty. However, transferring money instead to a pooled special needs trust will not result in a gift penalty. Very, very important. Number 3, money in a pooled trust can be used for anything that the disabled Medicaid recipient needs or wants. Very, very few restrictions. The only time that there are restrictions is if the Medicaid recipient is also a Social Security income, not Social Security retirement, but Social Security income benefit. Then there are a list of 10 items that the trust cannot pay for. But if you're not on SSI, if you're only on Social Security retirement, then a pooled trust can pay for anything the Medicaid or disabled beneficiary needs or wants. It can pay for necessities like additional home care hours or entertainment expenses, like going to a baseball game or going to the theater or travel expenses. However, pooled trust will not allow you to abuse this, right? What I mean by that is, let's say that a special needs individual wants to take a vacation or a trip. The pooled trust is not paying for a family reunion. The pooled trust will pay for whatever is reasonable for the disabled beneficiary to be able to handle traveling, right? So they'll pay for their hotel and their airline expenses, and maybe for the hotel and airline expenses for one individual if they need someone's assistance in order to successfully travel, right? But they're not going to pay for the whole family to go on their trip. Another way pooled trust companies sometimes see the attempted abuse is, for example, if a disabled elderly relative is living with someone who isn't disabled, who isn't on Medicaid, and let's say there's a mortgage payment. Well, let's say there's home expenses. Well, if there's 3 people living in the home, one of which is on Medicaid, who is the beneficiary of the pooled trust, they're not going to pay for all of the housing expenses that go along with maintaining that house. They may pay for a third of it, right? If there's 3 people living in the house, that might make some sense. So these trusts really are designed to only pay for what the disabled individual needs or wants or their fair share of expenses. Number 4, you cannot be the trustee. A family, a relative cannot be the trustee of a pooled trust or a pooled special needs trust. You have to use a non-for-profit professional trustee. They are not fee-free, but typically their fees are very reasonable. You'll typically find a one-time entrance fee, usually around $500 to $1,000. That's their welcome to the family fee. And then on a yearly basis, not a monthly basis, on a yearly basis, they'll charge somewhere typically between 2 and 3% of whatever they're managing. You have a choice typically with pooled trust as to whether or not you want that money invested to try to do better than the 2 to 3% fee, or if you want to hold the money in cash and accept the fact that the administrative fees will somewhat eat into the principal, and that's a very personal decision. Number 5, if there are funds left in the trust when the Medicaid beneficiary passes away, the trust is obligated to notify Medicaid. Medicaid will then send a bill. They keep track of whatever anyone over the age of 55 has, what bills they've incurred while on the Medicaid program. And Medicaid wants to get paid back first. Only if there's money left over after Medicaid is paid back is there a chance that family members might get to inherit. There are a couple of exceptions to this. If there is a married couple and both of them are on Medicaid, you can have both of them in the pooled trust, and if the first spouse to pass away has funds left over, typically the pooled trust will allow you to transfer whatever's left over into the surviving spouse's account. So that's kind of one exception to that. But generally what I tell people is, if you're putting money into a pool trust, you do so feeling comfortable that no matter what happens to anyone, money is going to be there for the individual on Medicaid. But you don't think of it as inheritance. You don't expect to see any of it after the disabled individual passes away. And that's just something we have to live with. So typically, especially when we're doing Medicaid planning for someone who has substantial assets, we're never recommending the pool trust as a standalone, like the only thing that we're doing. We'll use it in combination with other strategies that don't have that Medicaid payback requirement. So those are 5 things that are really important for you to know about pool trusts. I hope that's been helpful. If you are anywhere in Florida and you're interested in learning how to protect your assets now to qualify for Medicaid long-term care benefits, I'm happy to talk to you about pool trusts and all the other great strategies that we have to legally and ethically prevent you from having to go broke before applying for Medicaid. You don't have to wait 5 years, another big misconception. Again, this has been helpful. If you're interested, please call our office and schedule a consultation. We're here to help. Thank you.